Whether you think the current judges in the Supreme Court have gone as far as they could, given the fact that the government put in an affidavit saying we'll legislate this, we'll reassess the sedition law and therefore don't take any decision. Do you think the judges have gone as far as they could, or do you think they should have gone further, been bolder, firmer and struck the law down?
Well, look here, before striking down the law, the judges have granted a stay against the operation of the law. This is a very unusual step. As far as my experience goes, I can tell you, when a law is challenged, unless the judges are prima facie satisfied that the law is not constitutionally valid, they do not grant a stay of the operation of a law. But in this case, the Supreme Court has granted a stay of operation of the law. That shows the Supreme Court is very keen on examining the constitutional validity of this law, and the judges are prima facie, if I may say so with respect, satisfied that the law is lacking in complying with the constitutional mandate.
No,
that is why they have
sure,
granted
but shouldn't
the
the Supreme Court, if it's convinced that the law prima facie needs to be struck down, shouldn't they have taken a decision? Because what they've done in one way is put this matter on a loop which is infinite. You don't know when the government will come back, how they will reassess the law, whether that will be a sufficient dilution of the provisions of this draconian law or not. And therefore, if they were convinced that the law is wrong or its time has passed, shouldn't they just have gone further and struck it down?
No, look here, there is already a judgment of 5-judge bench judgment of Supreme Court in '62 in Kedarnath Singh's case, where this law has been upheld. So this, in order to strike it down, the Supreme Court has to constitute a larger bench, and this has to be done by a prolonged hearing and by an elaborate judgment. It cannot be done by an interim order. The validity of the law has already been upheld by Supreme Court. Therefore, now presently, but constitutional rights have undergone a sea change after the Maneka Gandhi's case under our constitution.
Satya Pal Jain, from the government's perspective, you wanted the Supreme Court not to take a view. In some ways, it has taken a view initially to say the law should be put in abeyance, or that sedition, a fresh FIR should not be filed. Is that something
the Supreme Court has taken a prima facie view?
Sure. Satya Pal Jain, how is the government seeing the order that's come out from the Supreme Court?
See, I personally feel, as a lawyer, there are 2-3 issues which need serious consideration. As Justice Ganguly pointed out, it is very unusual step that a provision of law has been stayed, put on hold till 3rd of or 4th of July. See, let's not forget, the validity of this law has already been upheld by a 5-judges bench of the Honorable Supreme Court as back as 1962. So therefore, in case you want to overrule that judgment, which says it is a valid decision, as he rightly pointed out, you have to constitute a bench of at least 7 judges, more than 5, to reconsider the whole issue. With all respect, I will, and all humility, I will submit that perhaps a 3-judges bench cannot overrule a judgment of the 5-judges bench. Secondly, so far as the main allegations against the law is concerned, and the most strong argument, forceful argument that is being given for striking down this law is that it has been misused. And I am saying again and again, if this is the argument that the particular law which has been misused by police, and that too by the state police of different states, if you have to strike down a law only on that ground, I think not only this law, you might have to strike down many other laws.
No, but it's not just the fact that the law is being misused. Also the fact that the idea of sedition is an idea whose time has passed. Countries like the United Kingdom, from where this law came, have in years gone by struck down the law of sedition. India is now amongst the countries where sedition continues to stay, whereas in a modern legal construct, it makes absolutely no sense. That is the most compelling reason. Any law can be misused, but sedition is an idea whose time has passed, sir.
No, sedition law needs to be there because there is no such type of slogans in America or China or England India tere tukde honge, inshallah, inshallah. You cannot tolerate the forces which want to break the country, which are against the unity and integrity of the country. What amounts to that is an issue which can need discussion. I agree. Simply criticizing government is not sedition. Protesting against the government is not sedition. Holding dharna pradarshan is not sedition. But at the same time, in 1962, this Kedarnath Singh's case, the Supreme Court itself said, what are the activities which will be brought under sedition law? These are activities involving incitement to violence or intention or tendency to create public disorder or cause disturbance of public peace. I don't think there can be any difference of opinion. If anybody indulges in these activities, why he cannot be and why should he not be booked? So therefore, there needs to be reconsideration as the Government of India has come out. We have to lay down certain guidelines, certain parameters, but I am personally of the view sedition law must stand on the law book.